Hi, my name is Ong June Tung.
My name is Lim Yen Wye.
Hi, my name is Tang Pei Sing. Hey, I'm Gan Hong Yin.
Hi, my name is Arisya.
Examine how the courts have served as the guardian of fundamental rights through the use of the rights-based conception of law within the judicial review process.
Based approach focus on the concept of liberalism and also individual autonomy. Rule of law is held to be a guideline for right-based approach as it encompasses the issue of freedom, fairness, and certainty by practicing three principles of the rule of law stated by evidency, which are no man can be punished unless there is a clear breach of law, equality before the law, and our rights are safeguarded by common law. The right-based conception in law is a framework that is usually based on human rights standards and used to protect human rights. Right-based approach is useful in development of law because it leads the development specialists to lie in two things, which are claims and processes. It makes the law concern more on individual rights, increase the focus on accountability, and respect the dignity and individual autonomy of everyone who claims to help, no matter their status in society, religions, races, and so on. Thus, it gives an opportunity for everyone in the world to participate in justice. As the UK exercised separation of power as a system of checks and balance for the UK constitutions, judicial review acts as a checking mechanism for public authority decisions. It is a court proceeding where the decision of public authority can be challenged as it was doubted to be unlawful. Through judicial review, the court will serve as the guardians of fundamental rights by using the right-based conceptions of law. The Senior Court Act 1981 stated that the court could not simply grant a leave of judicial review unless the applicant has a sufficient interest. In Part 54.4 of the Civil Procedure Rules, to claim a judicial review, the court permissions to proceed is required. The applicant must show that he or she has sufficient interest in the relevant matter to obtain the permissions of court to bring an action for judicial review. The test of sufficient interest was established in the case of R versus Inland Revenue Commissioners ex parte National Federation of Self-Employed and Small Business. By having such tests, the court can accurately focus on making decisions on genuine cases of grievance instead of those cases that do not have the objective of being genuine and will be considered as an unnecessary interference in the administrative process. Thus, if there is a decision that affect the personal rights and interests of an applicant or the society interest, the court will prioritize them and solve the issue by judicial review as soon as possible. However, the principle of exclusivity that was set down in the case of O'Reilly versus McMahon may violate human rights. If the applicants commence their proceeding by private law proceeding, they will not be granted a leave for judicial review. It will be an abuse of the court process if an alternative basis to bring the action has been used. The exclusivity principle was supported by the judgment from Lord Diplock as stated it was not a proper way for judicial review, even though the court has power under Rule 9 sub 5 to order the proceeding to continue as if they had begun by writ. Eventually, the court chose to protect the certainty of court proceeding instead of upholding the fundamental rights in this case. There are few grounds of judicial review which are illegality, irrationality, proportionality, and procedural impropriety. The court, when considering this ground, will take into account the fundamental rights in order to serve as guardians of it. Illegality was defined by Lord Diplock when the public authorities are acting in ultra vires. Fettering of discretions where authority acts unreasonably and refuse to hear applications or make certain decisions without considering individual circumstances by reference to a certain policy may infringe the individual rights. In R versus Port of London Authority ex parte Cannock, the court have held that a public authority has acted unlawfully by applying a policy too rigidly. Over-rigid policy is prohibited because it has to ensure that the Parliament's decision represent a true and proper exercise of the discretion in order to maintain the balance of certainty, rigidity, and individual consideration. Thus, flexibility in practice is important to uphold fairness. In British Oxygen Company versus Board of Trade, Lord Reid stated that the minister is allowed to operate some limiting rules if a policy or good administration requires it, but the authorities must not refuse to listen at all. Thus, in R versus Secretary of State for the Home Department ex parte Sim, imposing a blanket ban on journalist interview to the prisoner will not allow as the fundamental rights invoked by the applicant in present proceeding would be undermined. The actions may be improper as it breached the fundamental rights of the prisoners. The court will only interfere and undermine ultra vires when the limiting rules violate fundamental rights.
Irrationality is a concept that brings the courts further when reviewing the procedures of a decision being made by testing the legality of it, while also replacing the court's view of the merits of the decision by giving the courts more ways to intervene. Lord Green, Master of the Rolls in Associated Provincial Pictures House Limited and Wednesbury Corporation, had implied that disregarding the proper procedure of decision-making and citing bad faith, unreasonableness, dishonesty, and paying attention to circumstances that are irrelevant were encompassed under unreasonableness. The test in the case was set forth in determining whether the authority had acted or reached a decision in a manner that was so unreasonable that no reasonable authority could ever have come to it. It can be seen that the courts have set a high standard on unreasonableness, but it should also be taken note that if a low standard was imposed, then there would be a substitution of judicial discretion for the administrative discretion. However, the high standard of unreasonableness would be difficult to achieve in some cases, even though it involves breaches of fundamental rights, where claims would still not be allowed. It shows that there are some barriers for the court to overcome in upholding the fundamental rights. Moving on, the next ground that I'll be discussing is proportionality. Proportionality is the basic foundation of the constitutional protection of human rights. It is a set of laws that establishes the circumstances under which human rights are, as laid down in the Convention, may be disregarded. When public authority decisions are challenged in court, it is one of the most important factors to consider by the courts. Proportionality acts as an additional basis for judicial review to extend the review of administrative law towards protection for human rights. This ground had existed long ago, even before the enactment of Human Rights Act 1998, where it can be seen in Smith and Grady and United Kingdom case. The enactment of Human Rights Act 1998 allows the court to have a more unified approach towards the standards of rights entitled by an individual. Section 2 of the Human Rights Act 1998 enables the duty of court to take into account human rights in their judgment. Several direct impacts can be seen, such as the arrested person shall be informed promptly of the reasons for the arrest under Article 5. In Ex parte Smith, the ban of homosexuals from armed forces was lifted and was successful in challenging the European Court of Human Rights, where this illustrates the impact of the Human Rights Act to judicial review. Classic cases can be seen in Ex parte Sims, which demonstrate the power of proportionality. It overturned the decision of the Court of Appeal by lifting the blanket ban on journalists interviewing prisoners with view to publications, with reasons breaching the Article 6 of Convention rights. Section 3 of the Human Rights Act 1998 stated the primary and secondary legislations must be executed consistently with the Convention rights, so far as it is possible to do so. The court's interpretation must be in accordance with the individual's rights and compliant with the Convention. When determining this, courts will consider whether the measures are proportional to the legitimate objective. The courts have adopted the ideas of proportionality and the necessity in exercising their interpretations under Section 3 in order to give a greater protection to the individual's right, more than the Wednesbury unreasonable test which is employed in judicial review. The judgment in R versus A, complainant's sexual history, provided guidance on how to proceed under Section 3. First, the court had to determine whether the legislative provision in question infringed on the plaintiff's right. If there was, the court had to find out whether or not the interference was authorized by law. Then, they would have to consider if the requirements of the proportionality principle were fulfilled. This means that the court must be satisfied that the methods used to infringe on the rights were justified to accomplish the legislative objective.
As what is mentioned previously by Rachel, it can be seen that the ground of proportionality has a great extent in upholding the right-based conception of law. The enactment of Human Rights Act 1998 strengthened the fundamental rights by imposing a duty for the court to interpret legislation compatible with the Convention rights, and also made sure that the judgments did take human rights into account in cases if the individual's rights were violated by public authority. Some decisions might be valid and reasonable, but it may breach the rights entitled to an individual. Hence, here, the Human Rights Act gives the court a greater power to serve as a guardian of fundamental rights. Also, in the case of R versus Secretary of State for the Home Department ex parte Daly, it can be seen that the judges in the House of Lords were willing to expand the common law doctrines to be in line with the European concepts of proportionality. To further discuss whether the courts have served as a guardian of fundamental rights through the use of rights-based conception of law, Section 6 of the Human Rights Act requires the court to give judgment in a way which is compatible with the Convention rights. This section plays a very important role in ensuring the courts can serve as a guardian of fundamental rights. It obliged the court to protect the Convention rights when delivering judgments. It does not limit the duty to cases involving public authorities, and the courts are required to perform that duty in all cases to ensure the fundamental rights are upheld. This can be seen in Venables and Thompson versus News Group's Newspaper Limited, where Lord Justice Butler's laws, by recognizing the defendant were not within the definition of public authority, and the plaintiff asserted their right to Article 8, and the courts granted an injunction against a private body. Though the question of whether the Human Rights Act 1998 provides a horizontal effect has been a topic of intense debate by many legal scholars. Many of them argue that it may be an indirect horizontal effect, such as Oliver Dawn in his journal article mentioned to include private bodies exercising public functions to be liable if they breach the convention rights. However, our group tends to support the extreme side from Professor William Wade by stating that the court must be an effective agent in all cases, recognizing the direct horizontal effect, and this view may be used to interpret the Human Rights Act. In this view, private bodies and individuals are subjected to the convention rights by establishing a new cause of action. This view may be criticized as extreme, and it may result in an overabundance of concern for human rights, but it seems to enable the court to uphold the fundamental rights better in all the cases than judicial review. Comparison between the use of irrationality and proportionality was considered in R versus Secretary of State for the Home Department ex parte daily, where the blanket policy cell searches and the breach of a confidentiality of attorney-client privilege was declared unlawful under the Human Rights Act 1998 and the Wednesbury Anxious Scrutiny. Though Lord Bingham stated that his judgment was formed by using the traditional approach of the common law principles, but due to the nature of this case, the use of common law and the convention yield the same results, but this need not always be so. His lordship stated that in Smith and Grady versus the United Kingdom, the applicants were not provided with an adequate remedy for a breach of their rights because Human Rights Act 1998 was not in place at that time and the Wednesbury threshold was set too high. It failed to protect their rights under Article 8 of the European Convention of Human Rights. Following the incorporation of Human Rights Act, however, domestic courts now have a duty to determine if a convention right has been violated, and if so, provide an appropriate remedy within the Act's scope. Even if the Wednesbury unreasonable test would say that the decision was not unlawful, but by following the Human Rights Act, it provides a greater scope of protection to the individual's rights. Lord Steen in this case too mentioned that as a result of the variations between the traditional grounds of review approach and the proportionality approach, different results may occasionally be obtained. The courts should employ a proportionality test in order to strike a fair balance between the individual's rights and the public interest.
Under the Human Rights Act, there are absolute and qualified rights where the court will consider in the judicial review process. Absolute rights means there is no restriction, limitation of rights that can be done by a government official. Hence, we can see that whenever a right is absolute, there is no room for proportionality. Absolute rights includes right to life, Article 2, prohibition from torture, Article 3, and the right to fair trial, Article 6. In McKern and others versus the UK, 3 members of IRA were killed by soldiers as they were suspected of holding an equipment to detonate a bomb. The applicant alleged that there was a violation of Article 2 of the Convention as the soldier could have controlled their action without needing to kill the suspect. The court contended that there was a breach of absolute rights since there was no justice of derogation submitted under Article 15. If there was, derogation under Article 2 is only justifiable in lawful acts of war, and in this particular case, it was not. On the other hand, qualified right can be interfered with and must be lawful. Government and public bodies must ensure to follow 3 requirements, which are lawful interference, legitimate reason, and reasonable interference. Qualified rights include such as rights to liberty and security, Article 5, rights to private and family life, Article 8, right to freedom of expression, Article 10, and so on. As stated in Article 15, the right of derogation can be used in time of war or other public emergency threatening the nation's life. In A and others versus UK, the court protects the UK national security, as the government decides it was necessary to allow foreign nationals to be detained under Article 15 of the Convention. The case of Branningen Bright versus UK illustrates the derogation of Article 5 and Article 13 of the Convention. The case involved two suspected members of IRA who were arrested by Northern Ireland police, held in custody for 6 days and 4 days, respectively, and were denied access to a solicitor. The court ruled that this is a genuine case of terrorism-related violence, and therefore UK had not breached Article 5, which is the rights to liberty and security of the Convention, having submitted a notice of derogation under Article 15. Thus, Article 13 was subsequently not breached at all. From the European Court of Human Rights cases above, there are alternative pathways available for parties to seek to uphold their human rights, which are through judicial review grounds. However, even they tried their case via judicial review, their outcome will be similar. The derogation order seems to act as a limitation to avoid the court serving as guardians of fundamental rights. Also, there will be a legitimate objective that prevails and justifies the interference of human rights. Furthermore, Section 23 of Terrorism Act 2006 extended the detention period from 14 days to 28 days. By observing this statement, it was obvious that it breaches Article 5 of the Convention rights. But the UK practices parliamentary sovereignty and its statute hold the supremacy value. There is no effective remedy to be provided except relying on Section 4 of the Human Rights Act 1998, declaring the provision incompatible with the Convention rights. Clearly, there are certain limitations to the function of court in protecting human rights, where in this case, the court has no power to uphold the fundamental rights as legislation prevails. There are also some limitations towards the court when serving as a guardian of fundamental rights in judicial review claims, such as the Human Rights Act has no retrospective effect. This was supported by Lord Slin's judgment in R vs. Cancel by stating that the Parliament would state clearly if they intend the Act to have retrospective effect. Another limitation to it will be All-Star Clause. Although now the approach has evolved after the Annie Mismake case, a valid All-Star Clause without error of law will still prevent the court from reviewing it. These limitations have prevented the court in some certain cases to uphold fundamental rights. However, when it comes to remedy, McManus' certiorari declaration are available for judicial review. Damages and injunction serving as equitable remedies can also be sought by the parties via judicial review of delegated legislation or decision by public authority. It can be seen various remedies available for the individual to protect their fundamental rights.
Procedural justice gives an individual a fair opportunity to influence the outcome of a decision. There are two heads to procedural impropriety, which is when the decision maker has failed to observe procedural rules stated in a statute or secondary legislation, as well as the decision makers fail to observe the natural rules of justice and fail to act fairly. Natural justice and the duty to act fairly embody two concepts, which is audi alteram partem, where a person should not be criticized without a fair hearing, and nemo judex in causa sua, where no one should act as a judge in any matter since decision made should be free from bias. Article 6 of the ECHR, now enforceable in the Domestic Court under Human Rights Act 1998, mention requires a fair and public hearing within a reasonable time by an independent and impartial tribunal established by law. Since the Human Rights Act came into force, the applicable test for bias was set out in Porter and McGill to see whether a fair-minded and informed observer, after considering this fact, would conclude that there is a real possibility of bias. Even though some criticism and uncertainty has arisen, it will still comply with the Article 6 of ECHR. Moreover, the principle of fairness can be seen in Ray HK, where it was held that immigration officers had the duty to act fairly even though they were not obliged to hold a hearing before deciding the immigrant status. The case here showed that the duty for the public body concerned to give a hearing would be higher if they had created a legitimate expectation in the mind of the complainant. There are some requirements under duty to act fairly, such as right to make representation, Knowing the opposing case or giving reason for decision as illustrated in Stephen and General Medical Council. The court held that although there was no general duty to give reasons, they should do so in light of the Human Rights Act 1998. From all these above, it can be seen that the court focuses the procedural justice to guide the fundamental rights by enforcing various duties for the public authorities to obey. A legitimate expectation usually arises when the decision maker has used the words or action that lead the complainant to believe and understand that certain procedures are going to be followed when reaching a decision. Hence, the decision maker now has to adhere to the procedures that have been indicated and not ignore it. R&L Liverpool Corporation ex parte Liverpool Taxi Fleet Operators Association has recognized the principle of protection of legitimate expectation and is a concept that gives rise to judicial disagreement as there were perplexity in determining whether the correct procedure from a legitimate expectation has to be followed or whether the expectation to be protected can be substantive as well. Sidley J. mentioned and accepted that procedures as well as substantive legitimate expectation can be protected but was rejected by Hughes Lord Justice as he stated the substantive matter should be dealt with the Wednesbury unreasonableness. The principle underlying the requirement that a public authority must honor the practice or promise that has been adopted is a good administration. It is a legal standard even though not found in the Convention of Human Rights, but has also taken into account that rights such as right to fair trial should be taken into consideration. It can be seen above that there are some argument in whether the court had upheld the fundamental rights. However, evidence has illustrated that the court are willing to protect the fundamental rights by taking reasonable steps in developing the judicial review process. Right-based conception is important in constitutional law, not only because it is part of the consideration when judicial review is taken. It did exist even earlier than the existence of judicial review, which is during the reign of King James I in the case of proclamation. This case is a starting point of raising the concern on human rights, where King James' power was against when he wanted to use his power of proclamation to raise more money outside of the parliament. The court then set down the principles in English law to restrict the power of royal prerogative and lead to the creation of the Bills of Rights 1688, which deal with the issues related to parliament and crown, and also the doctrine of parliamentary sovereignty. In conclusion, right-based conception is an important element in judicial review to achieve the aim of protecting and respecting fundamental rights. However, there are some limitations mentioned above where it prevents the court from upholding the fundamental right. In general, it can be said that the rights of an individual have been taken seriously in the judicial review process by the court. At the same time, the enactment of Human Rights Act 1998 in great extent strengthened the power of the court in serving as a guardian of fundamental rights. From the illustration above, it can be seen that the court did take considerable action to ensure that the right-based conception is functioning well in judicial review.